Jen,
Hi, Eric. How are you?
I'm good. I'm not great. I'm
No,
not great this time.
no.
It's allergy season, I got
Yeah,
a lot going on up here. I'm gonna try and make my way through this today, but I'll tell you what, it's bad out there, Jen.
it is. It is. It's like it's snowing flowers and pollen out there, which is a big difference from 20 degrees below that it was last week.
Yeah, I kind
So
of feel bad complaining about it, but man,
you should feel bad complaining about it.
it's been tough. It's been tough.
So
Well,
what you're telling us is that you're not at 100% here today, so we shouldn't expect the best from you. Is that what's
I'm not
going
sure
on?
anybody should expect 100% ever from me.
Oh, we don't.
So this is less of a disclaimer, I guess, because I don't think anybody has super high expectations of my
sure.
output
Yeah.
anyway. Just a general comment, it's just something I wanted to bring up. It's nasty out there.
It is nasty out there. It is.
No, I'm gonna do what I can to be operating at as high a level as I'm capable of.
On
100% might
allergy
be asking
medicine.
too much, but
All right.
here we are.
Here
It's
we are.
another Just the Tips with Jen and Eric.
Yeah.
Thanks for joining us. Thanks for coming out. Today we're going to be talking about contract addendums.
Oh yeah. Dun, dun,
Oh,
dun.
that's an exciting topic,
Dun,
huh? We should
That's
save
weird.
this one for some whiskey. Maybe really jazz it up a little bit, but
We can
yes,
just drink whiskey.
we could. It's not a whiskey tips though.
It's
This
not
is
a
just the
whiskey
tips.
tips.
So
This
we're
is
not
just
talking
for-
about claims. Whiskey tips is claims related. This is just the tips, and we are going to be talking about concepts, risk management type issues that a lot of firms are facing. I know a lot of firms are facing this particular issue because I think in the last month it's come up probably 15 times.
Yeah. So let's talk about the timing on that. Is it a little suspect? Is this because we are exiting design phase and really starting to ramp up construction phase?
Could be.
You
Could
know,
very
so
well be.
payments are being looked for, and all of a sudden we've got
Maybe projects that have kind of been sitting on the shelf for a little while are starting to ramp
COVID,
up, and
yeah, coming
people are
back to life.
realizing, oh shit, our contract might not be what we thought it was.
Right.
Yeah, so there's a lot of reasons why I think we might be seeing an uptick in contract addendums. Let's back up real quick
Sure.
and just talk about what that is.
Right.
What's a contract addendum? What does that mean? So you've negotiated the terms and conditions of a contract for services. An addendum comes out for one reason or another, but it's really to change those terms and conditions of an existing contract, right?
Right. Right.
So that's why we're seeing them. Our clients, I think for the most part, do a really good job of sending those things to us. When they do get those, and that's probably the biggest piece of the puzzle is, if you're not sure what that addendum is or what it's for, shoot it over to us and we'll kind of help you navigate through that.
And let us know it's an addendum. I think that's an important part of it, right? So often we'll get these, hey, can you take a look at this? Can you review this? Is this okay for insurability? And, we'll take a look. But if we don't know that there's some other piece that it belongs to, particularly if they're poorly worded, or they're just expected to be added as an exhibit and it doesn't specifically say, this is an addendum to AIA B101 dated, blah, blah, blah. We might not know that this is really an addendum, or we just get a piece of it that lists out the insurance requirements. So let us know so that we have some, or can ask for some background.
And so addendums aren't new. Obviously,
No.
this is not something that's brand new, but what we're seeing an uptick in, and the reason I think that we're reacting to it is because more and more the addendums that we're seeing are changing the terms and conditions of a contract retroactively.
Yes.
So it's effectively putting those terms and conditions in place from the start of the project, whenever that may have been. And so, if it's a term agreement, maybe it goes back even further. But that can be kind of an issue if you're signing off on a contract change for something that isn't going to take effect today going forward. It's going to take effect from the date that you signed the original contract. And so there could be a lot of issues with that.
Yeah. So let's set the stage for how these things happen. So you are, you're finishing up a phase in a project. You have submitted documentation for payment from your client, and you get a call from the rep, or the client, the owner, whomever, and they say, hey, listen, we just realized, or our legal department just let us know, or our compliance department just let us know that we don't have this document in your contract. So we need you to go ahead and sign off on this before we can pay you. And I just want to point out the obvious here, right? It's just there's a little bit of ick factor there, right? Like imagine doing that with anything else. I hire you to do work. We negotiate the terms of your employment contract prior to you starting. And right before your first payday, I go, hey, Eric, thanks. This has been great. But compliance just let me know that instead of the $80,000 a year salary we were gonna give you, we can only give you 40. And I need you to sign off on that before we give you your first paycheck. Yeah. Also, all of the services that you were contracted to do have changed.
Yeah.
So go ahead and sign this, and then we'll go ahead and give you your paycheck. So there's a little bit of an ick factor.
Yeah, and that's always how it feels, right?
It feels
When
that
I
way.
see them, you know, on my side of all of this, that's what it seems like to me is we've negotiated the terms and conditions of my services for you. And now all of a sudden, when it comes time to cut me that check, you're changing the terms and conditions of those services, and whether it's payment related or scope related, or, you know, whatever other terms of the contract they're trying to amend. Like we've already gotten past this point. We in good faith negotiated these terms and conditions. And now you're kind of holding my payment hostage until I sign off on these changes. Well, it's kind of a dirty practice. That's how it feels. I know.
Feels right.
I know that that's not always in practice the way it is. But that's also a little bit of what makes this kind of scarier in practice, because if that's not the intent, if that's not what's happening, now you've got people involved in this who may not really grasp fully the impact of what these changes in the contract are, and how it's going to affect a lot of other pieces of the contract, not just whatever that thing is that they're trying to change, right?
Right. So in the event that you have an owner who is a singular entity, right? It's not a municipality that may really just have a legal department that said, oh, you forgot this, or we've changed our stance on this. So everything going forward, when we see that quite a bit, and that's still a little bit scary. So it's usually not a nefarious scheme to get you to sign up for more things. It usually is something is missing. Timing is always a little suspect. Sometimes it feels like money management, feels the way that like, oh, we never got your certificate that, we sent 15
We're
times, right?
missing this one document that we need to release your payment.
Sure.
We sent that 100 times already.
Right. So it always feels a little bit icky. And then you have your state agencies and so on, or your large entities who make wide spread sweeping changes. And that's where it can get very dangerous, right? So if you're using this boilerplate addendum, where after you, like you said, you just negotiated the terms of your contract, what's fair and what's equitable for all of the parties involved. And all of a sudden, this legal department has this boilerplated addendum that changes what they think they're changing, but changing other terms in the contract as well. So that's
a big, that's a huge issue, right?
Yeah.
So the legal department looks at it and they look at that original contract and they say, you know what? This indemnity provision that is signed off on this contract, we can't do that. We can't have that provision. Or, you know what, this insurance, the set of insurance requirements was not complete enough. We have to add all these other things to it, to be compliant on our side.
Mm-hmm.
And I just saw one recently, and it looked to me like it was probably just a boilerplate document that somebody found, or somebody thought, okay, I like this set of insurance requirements, let's use this. Okay, maybe that's not a problem. There are other issues associated with changing insurance requirements after the fact, and we'll get to that in a second. But the real problem here is we're using this document that is 4 pages long. It has 16 sections to the addendum. If all we're really trying to change is the insurance section, we're not really considering the fact that there's 14, 15 other sections to this addendum that are also changing the terms and conditions of the contract. And that's really the big problem that I'm seeing with this, is that lack of sensitivity to the fact that we might be trying to target this, but we're creating this much collateral damage in the process. And we have to kind of create some sensitivity there so people realize what they're looking at, and you can have those conversations.
Right. So who are the parties that need to be involved in looking at these addendums? And depending upon the breadth of the changes and what they're looking to do, you will likely want to have the attorney who reviewed that contract to begin with involved in it, including the original documents. So there's something to look against. You may want to have, your risk managers, people like us, look at that also with the other documents so that we can see what has changed. You'll want the project managers or people who are involved in the services to begin with or negotiating the contract to begin with involved. And sometimes those people change. So you may have a term agreement, for instance, a master services agreement that goes back a few years. Maybe personnel has changed in the office. Maybe the principal who negotiated the terms is no longer actively working, but you still want some insight into whether or not there were changes in scope of services. Because when we look at contracts, we're not really looking at scope of services. I'll glance through quickly to make sure that there isn't anything in there that should be, out there, like site safety during CA services and so on. But generally, I'm not looking at it to see whether or not the scope of services match. And we have seen instances where the scope of services has been changed in the addendum, and it was very detrimental financially to the client.
Yeah. I mean, you're right. That's not something that we're going to look at because it's not really risk management based, right? Whatever, as a firm, you're making these business decisions, you're negotiating your scope of services, whatever is a basic service versus an additional service. That's all part of what you are negotiating on the front end. So, and that's a great example of how these little nuances can become really big deals. We had, the original contract put the design firm on construction phase services as an additional service, as an add-on service. So their basic services really just went up to construction documents, and whatever the owner decided they wanted into the construction phase, or whatever was negotiated after the fact, was going to be on sort of a time and materials basis, so to speak, and that was going to be negotiated separately. So then this addendum comes along and includes construction phase services as a basic service. And, that's, again, your attorney's probably not going to catch that. We're probably not going to catch that, unless you're doing a side-by-side comparison of every aspect of the contract in the addendum. That's something that the firm really needs to catch, because they're the ones that have a full understanding of what the scope originally was versus what this document is saying it is. And if we're treating these addendums like they're just ministerial and we're just signing off on it to get payment for a certain phase of the project, we're going to miss that. That's going to slip through the cracks. And so in this particular case, that's exactly what happened. And to your point a minute ago, it had a lot to do with the fact that design services were provided. Project was delayed. By the time the owner decided they were going to ramp back up into construction of this project, there were some project manager changes, personnel changes. The person that signed the addendum didn't really take the time to look at what the original contract said. And, now you've got an owner sitting there expecting construction phase services out of the firm for the fee that they already paid them. And, so now you're providing free services. And so, there are other risk management issues with that. If you're providing free services, you have a tendency to maybe put less skilled people on it. And there's a whole host of problems with that. It's not necessarily an insurance. It's not necessarily a risk management issue. It's a payment issue. Right? Now you're on the hook to provide free services. We see it with contract issues. We want to change the terms of the indemnity provision. Okay, well, what does that mean? Did you just sign off on an indemnity provision that's no longer insurable versus the one that was originally negotiated? That's a big deal. What about insurability or insurance provisions?
Sure.
Contract.
Yeah.
You sign off on changes to the insurance section that may add things like waivers of subrogation and additional insured that weren't part of the original contract, but now we're signing off on that now, effective back to that date. what does that mean? We had this issue come up too.
Right. So when that happens, there are insurability issues. Your insurance policies generally, a waiver of subrogation, for instance, waivers of subrogation in most standard policies say something like this. We will waive our rights of subrogation. That means to go after another party. If you agree with that entity, so usually it's not just this broad brush, everybody and anybody, but with that entity to waive rights prior to an incident. I have seen insurance language that says prior to the project start. So if you sign off on or waive rights of subrogation and it happens retroactively per this contract, or contract addendum that you just signed, you could find yourself with a contractual obligation to waive rights of subrogation that your insurance policy is not going to back you up on if the incident already happened. And let's face it, there are lots of times that incidents happen on construction sites that a design professional might not know about until they get something in the mail that says, now you're brought into this.
Right.
Now you can make the argument that you had no knowledge of it, but the incident still happened. So
Depends on,
whether or not
that comes down to your coverage. It depends on the policy. They're not all the same.
And this will be a whiskey tips topic, but we do have a coverage attorney that we work with, and he actually had to have a conversation with a client that said, you signed this agreement for additional insured status for this other entity and to pay their damages related to your services, and you signed it after the incident. Your insurance will not respond.
Right.
We're looking at about $1 million claim. You are better off just shuttering your business.
Yeah.
I mean, imagine having to have that conversation with someone. That's really dangerous. So there can be, not saying there are, but there can be insurability issues. So these happen. They happen quite often. They seem to be happening more this time of year, but also because of long delays on COVID materials, the availability of workforce.
Mhm.
So you see a lot of delays, and then people looking at it and go, things have changed, or my attorney looked at it, or I have lenders now involved that want some different language that needs to be included there.
Right.
And that lender language may not be as as innocent as they want you to think it is.
Right.
So you have to go back to the original terms of your contract. What did you sign up for? What did you say? And remember that you can't say no. I mean, I know that's tough and everybody wants to get paid, but if it's egregious and if it's really standing in the way of you being able to, feel like you're being fairly treated in the contract, in the project, then, you do have that option. It's a business decision. So when you're faced with these addendums, take the time to give them their due time and attention. They are important to look at. Make sure you're getting the right parties involved. And then also, when you're looking at these, ask yourself a few questions. What are they asking for? What are they trying to change? Like you said before, what's the intention here? If they're just trying to change the language on this indemnity or add a little piece here, why do we need 15 paragraphs?
Mhm.
Maybe this isn't appropriate
I
for
think
me.
that's the biggest thing with all of this.
Yeah.
And you're right, whether it's contract negotiation or, lender certification, addendums, whatever it is, if you don't like the terms of that form or the language in that document, push back. It's
Mhm.
okay to push back.
Yes.
Especially, if you're in a situation like this, that it could potentially have far reaching other issues. Definitely push back when you feel it's necessary, but that's the first step, right? When you get this addendum, they send it to you and they make it seem like it's really no big deal. We just need this to document the file, and then we'll go ahead and release your payment. And you think, oh, great, this is the last thing holding up
Yeah.
this payment I've been waiting on for 8 months. I'm gonna go ahead and sign this as fast as I can. Well, pump the brakes on that, understand what it is, read the document, and then have a conversation with them. Like, what are we trying to accomplish with this? Like you just mentioned, let's get right down to the point here. What is the issue? And a lot of times what we find is that the client is presenting you with this addendum and they're trying to change the terms of the contract because they've gotten burned on something
Yeah.
that they're trying to clean up now in all of their other contracts so that they don't get burned on that one thing again. Okay, well, let's understand what that was. Let's understand the circumstances of that.
And whether it even applies to
Whether
you
it
as a design
applies,
professional, right?
and if we can narrow that down in this 4-page addendum to
Mhm.
exactly what you're concerned about, then we can do that.
Right.
Otherwise we have to really look at the full scope of the addendum versus the contract, make those comparisons, understand what they are, give you the ammunition that you need to either push back or decide as a business decision, we're gonna accept this. We're
Or
fine with it.
negotiate,
Yeah.
or get some input from your attorney, get some input from us and
Mhm.
find out how we're going to negotiate that. So it's fair on both sides and that we can, get past this. But the other thing to consider, and I think what a lot of people don't consider, is the impact it may have upon their subs,
Right.
right? So if you're the prime and you're being presented with an addendum to change the terms of the agreement, and you have used incorporating contracts like a C401, right, or an E570, and you are incorporating the terms of the prime for most of the heavy hitter things, indemnity, standard of care, whatever, as is standard with those standard docs, you likely have a requirement in your contract to notify a sub of a change of terms and
Mhm.
give them ample time to review it. So don't be so quick to sign off on it without also having that review with your subs to make sure that they're cool with it too, especially if there are things that are impactful upon them. Maybe there's document ownership issues where you have to get permission from them.
Right,
Maybe
right.
there's expanded, indemnity that they may not be cool with, that you have to get them to sign off on to.
Increased insurance limits. things
Increased
like that
insurance
might,
limits.
have a different impact on you than it would a small firm that might not have the ability to get those limits.
Even some of the things that, go with that primary non-contributory language on commercial general liability. Depending upon the carrier that your sub is with, they may not have that availability. And because general liability isn't the big exposure for design professionals, maybe they haven't felt like it was necessary to have, maybe their agent felt like it wasn't necessary. We always put our clients with carriers that allow for that, but there are plenty of small firm carriers that don't offer those coverages for one reason or another. So it's important that if you are signing off on an addendum and you do have subs, that you consider how those changes are impactful upon them as well. It's not just you that's going to run into that. And then when are the changes effective? Are we talking about now going forward? Are we talking about retroactive back to the beginning of the services that I was providing? What things are impacted in there? This is not just issuing a certificate that says, hey, here's an additional insured, or hey, here's a waiver of subrogation, everything's fine. Sometimes those will not be effective at all because of the timing of an incident or the timing of the signing.
Yeah. So bottom line, get in touch with us.
Yeah.
If you're unsure about what it is or what it's doing, the impact it may have, obviously always talk to your attorney as well, talk to us. We'll help you through it. That's what we're here for.
Absolutely.
And, we're happy to do it. It's kind of our thing.
It is
Like
kind
it
of
or
our
not.
thing.
That's what we do.
All right. Well, thank you so much. And thanks, Eric. Great job today.
Hey, great job to you too. Thanks for
Thanks.
coming out today. We'll see you next time on Just the Tips with Jen and Eric.
See you next time.